won't wage an emergency.
This is Alex Murdaugh at 4147 Moselle Road. I need the police to answer immediately. My wife and child got badly.
Well, good morning, friends. I hope everybody's safe and sound on this Monday morning. It's +2 in the Rockies. So I thought I'd come on a couple minutes earlier than I usually do. Looks like possibly Africa's going to start getting quiet. So I had found some, let's see here, giraffes. And I thought, oh, let's look at those. I thought, let's look at these for a few minutes while we're waking up. Let's refresh it here. There we are. So what have I heard about an earthquake? I just got on and I seen that an earthquake was being mentioned. Should be another interesting week of trial. The nitty-gritty is starting to come out, and looks like we might be learning a little bit more about the Murdaughs. Look at all those little birds, like they're everywhere on them. And then, are those quails? Those look like quails. Oh, nice. When I got up this morning, there was, I don't know how many around this little watering hole. Many. Okay, hang on here. I think. Good morning, Shauna. Are you serious? 7.9? Where was this? Good morning, my sweet. Where was this? How sad. Was it a place that a person would typically see an earthquake, or is this another one showing up in some random spot? I jumped on a little bit early so we could watch these guys before it got dark. And then I was also worried about this earthquake. Okay, I'm just checking here. Oh my goodness. Oh my goodness. Oh my goodness. They're saying at least 10,000. Oh my God. In Turkey, this one was really early this morning. And then I guess a minute. Oh, another one. Is Turkey, is that on a fault line? Oh, my word. Oh, my goodness. Wow. There's some strange stuff happening in this world these days, isn't there? Oh, my goodness. Well, God bless their souls, right? Okay. Oh, my goodness gracious. Trying to see if I can find anything. Okay, I think I'm just about. There we go. Absolutely heartbreaking. I don't know if that's on a fault line. That's kind of what I'm wondering. Unreal. Trying to find it in my other device here. I have a hard time with heartbreak like this. I want to hug everybody and make it okay. Can't do that with these situations. Start watching for our stream again. Not yet. It's okay. $10,000. Oh my word. So did it, was it through a city? I do not know much about Turkey, I must say. Nightfall in Africa. Look at all those little birds all over them. Do they have ticks or something? Are they up there eating bugs? Oh, thank God, Dandy. Oh my God. I'm sorry that they're even having to deal with anything remotely close to them. Oh, wow. Dandy, do you know if this is along a fault line? Or is this like a completely random spot? I really don't know much about that geographical area. I'm hoping I've got a friend possibly, well, a relative, I won't lie, hopefully popping in today, trying to get her onto the stream, not onto the panel, but just in. Okay, what is that? Like doing the splits and camel? Oh my God, you guys, it's an elephant. OMG, look at that. Oh my God. Look at the tusks. Oh my God. Okay, no trial today. We're going to watch this. Joke. Well, I'm sure thinking of your friend Andy. Live from Africa. See if I can find a live from Australia. I'd love to see some of their animals as well. Oh no. No. I certainly hope not as well, friend. Oh my God. I am one who really enjoys history and any kind of ancient site. I mean, we don't need to be destroying those, do we? Or neither does Mother Nature. An ancient site. Have you been there, Dante? Nothing yet, friends. I'll let you know as soon as they come on. I've got the volume on for them. We can jump right in. Was everybody leaving? The elephant comes in? Let's talk about the elephant in the room. I'm going to have to do a little bit of research on Turkey. I don't know much about that at all, that spot. You are very much the researcher, friend. My goodness. Devastating. Well, like I said, my prayers and thoughts are with them. Oh, having a drink of water. That is so cool. So I wonder if we're going to have another interesting day. And he's giving himself a cool down. Another interesting day in court. I don't have much doubt. I'm pretty sure they're not going to disappoint. So he's got like a vacuum hose or a vac truck hose, sucks up all the water and then bathes himself. Okay, 6 hours, less than 6 hours drive to Syria. That is one hell of a strong earthquake, 7.9. court should be pretty much right away. 7:31. So I do know someone who was raised in Syria. She's in her 80s. But I don't know much about it other than I really love the food. A lot of these countries are fairly small, aren't they? Everything I took in my travel and tourism, well, it's been 20 some years, but it's gone. I love the sounds. Still nothing. Do we know if this happened in a populated area, Dandy? And the fault line. Those are kind of my two questions about this. If it was a populated area and if it was along a fault line. No, are you serious, Shauna? Oh my God. I imagine. I would imagine. No. I might give an update as to what's going on, but I'll have to do some digging. Heartbreaking. Oh my goodness. Oh my God. Hmm. Yeah, I'm just sitting here just thinking about them, and yeah, very heartbreaking. Like, so many families, like millions of people. 2 million people are affected. Oofta. Oh, looky, who's come to visit. It amazes me, like they just, okay. Mm. It's just truly too much. My heart goes out to everyone. Well said, friend. Mm. I'm just sitting here trying to figure out if during a break or something I should jump over there and see what's going on, but I haven't decided yet. Sugar gliders are starting to go to bed. Oh my God. 1,000 people in one block. The building collapsed. If you guys are watching that as well, I will keep adding updates to my stream. Oh, I bet. Crumbled like toys. Mother Nature is very, very strong lady. Okay. Okay, here we go, friends. Okay, I'll go. I was hoping they'd be streaming, not yet though. Jump over here for a minute.
The state would call Mark Tinsley to the stand.
Raise your right hand and left hand on the Bible. Do you affirm the testimony about the court in this trial shall be the truth? So help you God.
I do.
Take a seat in the witness stand. State your name again for the record. Spell your last name.
Morning, Your Honor. My name is Mark Tinsley.
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would where you testifying before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And how long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
You have a statewide practice, or is it primarily?
To the extent I want it statewide. I mean, I handle cases statewide if I'm inclined to handle those.
Primarily focused in the 14th Circuit, is that fair?
14th and the 1st,
And the first? Do you know the defendant, Alec Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPD firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately,
And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alec Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, at when this case started.
Mr. Waters, my recollection is that I sued Alec Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believe that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdaugh, which is Alec's son. But I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
And can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday. So the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alec's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
Sure. My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alec's personal lawyer, brought me all of Alec's insurance policies. And so I reviewed them at that time before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
In a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right, and when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy. And so he had to then seek other coverage. And what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusion. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge. Is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing when insurance coverage was available?
Always.
And that was consistent all the way. For coverage he had.
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference. But yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alec sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything, and I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was no 20. September of 20.
Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
COVID, the court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. We'll show you what's been marked as Exhibit 401, State's Exhibit 401, and see if you recognize that document.
I did. I do.
All right, and what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right. Could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alec said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel, and about a week after I'd filed that motion to compel, Danny Henderson, who again was Alec's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right, and why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever. And so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alec thought there was a fix on, that he was just a placeholder or a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because it was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alec, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is kind of like that show Deal or No Deal. You may have the $1 million suitcase, or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that. Show me the books to prove that. What was your response from Alec's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alec's responses to interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right. All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can you
right.
read that?
List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
All right. And ultimately, what was the Alex Defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
Okay. And so ultimately, you filed a motion to compel. Is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others. Is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alex attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon. Ultimately, I think Amy left in February of 21. And by then, I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We all already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, the way to, again, like in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, that's what I'm trying to do, is put pressure on him to force him into a settlement. You don't want it disclosed? Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alex's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you've been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right. Put this up on the screen. All right, if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021. Is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah. So in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I just come back shortly before I was diagnosed with cancer. John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time, I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed the jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
I'm going to show you what's been marked as states 404, 405, and 406 to your for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple of weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021.
It's either the 10th or my recollection is the 10th. I know the emails say something different, but and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done. And he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at states 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at states 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right. Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as stage 407 and stage 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right. So the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec, all identification of all accounts. Is that correct?
It is correct that that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that way?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
After the murders happened, let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I've known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec. He hasn't done anything. It's Monday morning of the roster. Maybe you expect it to be continued. And he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things. But
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery.
Yes. It did.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case. So I would have ended the case against Alec.
You would have ended the case against Alec with just.
I probably, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
You had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
At some point, did you receive any call or any communication from the Satterfields about any recovery in the Gloria Satterfield death?
At some point, my recollection is it's early September of 21. Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement. And he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Go on, probably 1 second. Nothing further this time, Your Honor.
By the defense.
Good morning, Mr. Tinsel.
How are you?
You testified at length to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets. And that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insistent that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from him.
Sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money.
Right.
No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No.
You believe you were close to taking it to trial?
There was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial?
Sure.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex.
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard. Is that correct?
Correct.
There are many motions that had piled up and needed to be heard.
There were several.
There's several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had 1 or 2 motions. Some of the motions got resolved. One of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practiced in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video for mediation, for example. Correct.
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
You didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's look that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
We pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up. believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental request for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about.
sir, no one's asked you about it.
Okay.
And we'll get to it, but first let's turn to answers to first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B?
B. It's the first page of what's Exhibit B in here. It's right there, that's it. It's the first page after the motion, so it'd be page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts. And then you don't have to highlight or expand this stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property interest of property of every kind whatsoever, from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, etc. Profit sharing plans, pension plans, etc. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I've never been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you.
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
It's the record, October 7th, 2021.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied, or it's
If it was
it's
granted, would
premature.
you say granted?
Well, I think that's what it says. It's a practical matter when parties have discovery motions, oftentimes, like Alec has in his own statement said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge. So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
I just want to get the date this where is, which is October 6, 2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit, I believe.
And this was like a dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action,
Okay.
yes.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th date, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge what I've handed you, but.
Sir, I asked you what the ruling was on the motion.
Well, it-
compelled from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Ellick is that Ellick had, and his lawyers had, 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front of the
So you're saying
judge.
the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Ellick.
Because the law is how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Ellick's lawyers knew what the evidence was. They knew what the amendment was going to be and the allegations. And he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that appears you're suggesting now.
And again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up. And we saw the one that asked for financial information was deemed premature.
Not at all. You know, what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements. Now, it would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Ellick had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Ellick's getting these checks. There's no way these checks are going to Forge. There's no way that this money should be transferred.
And even if hypothetically had this hearing on the 10th and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him, isn't it true all you would have been all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that, you don't, in your opinion, there's no case law out there saying that's what you get, that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion. And then what are we going to do? We're going to try the case and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right? You just said ability to pay so your client can make a decision on whether to accept a settlement offer. But that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it.
So,
I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
You wanted pretrial ability to pay discovery to inform whether or not to accept compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. It would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. That's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case. And
then I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office, was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Thank you. Courts and buildings.
I like this guy. He's feisty. I don't know. The good old boys club there is still strong as ever. Alec doesn't even look a little bit concerned. That concerns me. Is the witnesses, let me see here. Is the witness the boat crash victim's lawyer? I don't know if he has something to do with
If
like the
hearing had
company
gone
or the boat
forward on
crash.
June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome do you would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't.
Let me just make it a little simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to
Just
issue.
break it down. An order would have issued at some point later. And what, if it were granting your motion, what would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
It's a voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten you've gotten his, would the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alec's.
Right. Would
accounts.
you have gotten what, a financial statement?
No.
The court would have ordered every account detailed listed to you, all his personal accounts, just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I told you that. a couple
Right,
times.
to subpoena,
Sure.
and
But that's different.
and
than
that would
him
have been
giving me-
resisted, and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
I'm not sure if what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating as same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but and we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that. Judge, I've been thinking about you. Thank you.
So just, and maybe we can agree on this. The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying the fuse was lit and you were going after his assets, and that fuse was going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money. Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
But it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. No further questions.
Yes, sir.
Very briefly, Your Honor. And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection.
There's only one.
Objection, Your Honor. Leading.
No, lead the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Alec was broke and you didn't believe it?
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets.
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec.
from Ellen.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol. So only on the documents that were filed.
So were those issues, though, in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed, these are the issues.
going to hand this back to you, but I'll show you what's been marked as States 407 so you can recognize that.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Yes.
And that's from October of 2021, is that correct?
It is.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Eddystone,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor. Nothing further.
Anything further?
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Step down. Next witness.
Your Honor, a couple things. Our next witness would be Ronnie Crosby. Just to let the court know, your court indicated Friday that we had kind of already established, as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forwards and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. Again, and thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself prep in the evening or whatever, privy to that particular conversation.
Any other comment about the attorney-client privilege issue, Mr. Griffin?
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
And so it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdaugh about, and that's where this is going. Or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to Mr. Lee Koch, and is that privilege? I'm at a loss here.
I don't know either, but I say, as far as the law is concerned, that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure. And I guess I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There's no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses and you want to call them as witnesses, if there are necessary witnesses to this hearing, you may proceed.
All right. Thank you, Your Honor. We would call Ronnie Crosby to the stand.
Okay? That is fine.
Raise your right hand.
Next thing.
Left hand on the Bible. You affirm the testimony about to give before in this trial shall be the truth, so help you God.
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Ronnie Crosby, Crosby, Crosby.
Mr. Crosby, how are you?
I'm okay.
All right. Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alec Murdaugh?
I am.
You see him in the courtroom here?
I do.
Where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting with in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alec's brother John Marvin's place, which is not very far from Alameda that I've been talking about. And I know I had been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him. And so we gathered there. I was present. Mark Ball was present. Lee Cope was present. John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but did the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day. And we were there for support. And he went over the events of that afternoon or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together. And I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were for me to hear them. I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct. And this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting, or this discussion have conversations with Alec about his activities the night of June 7th, 2021. They're outside of this. Is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on, because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and it may be pieces and parts. But what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this matter.
Anything further?
Yeah. Please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster could be interviewed by SLED. Is that correct?
That's correct. The purpose was that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed. And Jim, now that you speak of it, I do think that, well, Mr. Randolph did not come into the meeting. He and whoever brought him over did come by. Right. Those are two that I'd forgotten.
Yeah, and
then went back to Alameda,
where he died within hours of that. Right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
Okay. And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present.
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alec some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. What do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this. I never had the perception that I was representing him. Well,
did you, or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? Did you give him that warning?
Mr. Griffin, we're all lawyers. I don't, other than John and Buster that were there, I don't think anybody needed to say that. And it never crossed my mind that when we were sitting in a room and all of us were talking, that we were somehow representing Alec.
No, I understand that. And it's, okay.
And nor would I ever do that because I don't practice in the area that you do.
But it's clear that Danny had an ongoing attorney-client relationship with Alec, is that right?
He did with regard to the boating accident. He was Alec's personal counsel in that.
And Danny had sat in the initial interview in the that was conducted by Sledge Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, you know, for support because.
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the events of the evening of June the 7th. And my question to you is when Alec was making these statements, let me make it clear, were they just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where they're, you know, whether John had walked out when I heard any specific thing? I can't tell you that. I couldn't catalog because I said it's a little bit fluid. People come and go, and you know, law enforcement arriving outside and people walking out to greet them. I mean, it wasn't like the sled agents just showed up and it was, you know, some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please. That's all the questions I have, Your Honor.
Nothing further, Your Honor.
Thank you. This issue.
This particular issue, no, I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we, in discussions with the defense, that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all of this through. I know that we're butting up with the jury being here shortly, but
That can be done at a later time.
yes, sir.
Anything further on this issue regarding evidence of other crimes?
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but you know, that would be it. As again, for in-camera proceedings before Your Honor to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it. That's that side of the road.
We'll take a break of about 5 minutes and I will announce my decision regarding this other evidence.
Okay, so it sounds like they're going to come in soon. Let's see here. First off, I'm going to look at these eagles, see how they're doing. Beautiful. Just refreshing. Oh, they're both in there now. Nice. Beauty. I wonder if it's just wind. Oh. Oh. I wonder why. Oh, she wanted to eat. His turn. She's sure talking a lot. Are they, Dandy? I wonder if she was doing that because she was hungry. I just checked the Africa cam. They are it's all dark already. Sit on those kids, damn it. Oh, it's windy there. I bet. She's not squawking like she was. And he didn't come home with the salmon under his arm again. Busy, busy. Just look at me. No, wasn't drinking. Not at all. I don't know. Two of them. They're getting big. These guys don't talk as much. I got the volume on. So they just must not have their audio on. So cool when they stretch out their wings. So it looks like it's decent weather there. Hey, Shauna? 10 to 15% of their body weight a day. Okay. His feathers are a little, oh, I don't know why that keeps doing that. I'll try a different one. They should be back in court, I'm thinking, anytime. Same one, Alex and Andrea. See how it works. Yeah, no, that's not live. That's live. I will hear as soon as court goes back in. What the hell keeps doing this for? Drives me nuts when things kind of, forever and ever and ever and ever. I like my head movements. Yeah, I got this down. So I don't know what the Racoon Saloon's doing. They even have a driveway, so I don't know about this place. I seen something last night about, this is our one. That's those two. This is the one we just looked at, I do believe. It keeps zoning out. Yeah, I don't know why it keeps tuning out on us. I don't know why it... La, 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 la. Damn. Sorry, James. Gotta do it. Having problems with the baby eagles. They're timing us out. There we go. This is live. Oh, it's snowing on the Panda Bears. Wolong Grove. So I wonder where this stream is. I can only imagine. Sorry, Dandy. Got you going way up there still. Osprey are beautiful birds. Yep, lazy lazy panda time. If they weren't so damn funny, though. Yeah, can't accuse them of being smart or energetic, but they are absolutely hilarious. She starts dragging him. Him or her. Look at the get out of there, kid. Gotcha. Yeah, right, Dandy. Oh, that was far enough. Look, I can do a headstand. I would have got arrested if I had done that to my kid. Oh my God. Be back here. I think Court might be back. Let's look. No, not quite yet. Are they all in there now? Making noises in the courtroom. Not sure what they're doing, though. Oh my God. I do like the way that she plays with her cubs. I think that is like, you don't see black bears and grizzly bears play with them like this. Oh, I haven't watched Saturday Night Live forever. They're back in court, guys. Forever and ever. I am going to mute out.
This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of res gestae. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And before admitting this evidence, the court must first determine if it's relevant. Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence. And the court is required to conduct an analysis under Rule 403, which weighs the probative value versus the prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time. The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the estate versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife, Maggie, to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, have been sued following the fatal boat crash and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as the main depository for a substantial, if not most of the misappropriated funds. We heard testimony from Attorney Chris Wilson about confronting the defendant about the missing $792 and personal sum to him owed of $192,000 was later discovered. And that testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother, who was the housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case. And when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,300,000. Funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this case, since the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge. Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but is more probative than prejudicial. As to res geste, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and looming exposure of this criminal activity. And the state contends that that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime for which a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred, then that evidence is admissible under the theory of res geste or res gestae, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res geste, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged under the theory that the state is seeking to prove, that proof of it is essential to complete the story. Our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res geste. Further, in State v. McGee, the court held that where res geste, evidence of res geste or part of res geste is properly admitted, then no 404B or Lyle analysis is reached. However, as to the finding of admissibility of evidence, which I have done, and the finding of it within the res geste, I've nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order granting the state's motion later today. Are we ready for the jury?
I believe we are.
Your Honor, one point on Your Honor's ruling. I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence.
Okay. Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction
It will probably be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed limiting instruction?
Got it right now, Your Honor.
I must be waiting for the jury to pile in. I was over here trying to find information about this earthquake, but most of the stuff I can't restream. But I am still searching. I know some of you guys wanted to know. They're talking about the aftershocks. CNN is covering it, which I don't know if you guys...
Need to give this after the testimony or before the testimony?
Good.
So if I can't find something, there is one spot. So I do have videos, but just have to be careful going through them.
Sentence is necessary. The last sentence, I think, also has a typo in it. But I would, generally, though, I have no problem with this charge, and I have no problem with it being given before such financial evidence is received.
You've indicated those witnesses will testify later today or tomorrow?
Probably not late today, but almost certainly tomorrow.
All right.
So they're cutting in and out, not moi. The Times seem to be covering it. I'll check and see what's going on there.
Likely have led to a motive, lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record.
Yes, sir. I understand.
Showing no disrespect to the court.
No, I understand. Okay, we're ready for the jury.
State's ready to proceed, Your Honor.
Bring them on. Thank you. Good morning. It's right at noon. Well, 11:58. It's still morning. We embark on day number 11. Call your next witness.
The state of South Carolina will now call Miss Michelle Smith to the stand.
How you doing? Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Yes. Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Michelle Shelley Smith.
Take a deep breath.
Yes.
What is your first name?
Michelle,
Spell that, please.
Mushell.
Where did you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
Is it Michelle with a U?
You, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Ms. Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you don't mind just pulling this up a little bit, speaking into it.
Okay, thank you.
Thank you. Go ahead.
I was born in Hampton County. Have 4 grown kids. I was born in Hampton County, 4 grown kids, 8 grands, and I work for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable. Like you said, you had 4 adult kids.
Yes,
Then you said 6 to 8 grands.
it's 8 grands.
8 grands. Okay. And raised where?
Hampton, South Carolina.
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Ms. Smith?
Got married, raised my kids, and that's what my profession. That's it. Mhm.
And that is the hardest profession, raising children.
Yes,
You had 4 kids.
4 kids.
And when you were raising them, you were raising them, taking care of the
Yes,
family.
mhm.
And are any of your family here today?
Yes, my brother and my daughter,
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up? Is that your brother?
Yes, that's my brother.
And who else is here?
My daughter, Rochelle.
Miss Rochelle, will you stand up? Thank you. They here supporting you today?
Yes,
Don't take this the wrong way, but other than raising a family, which is the hardest job, were you doing anything else during that time period?
no, till 1995, I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you were raising your family?
Usher, kitchen ministry.
Kitchen ministry?
Mhm. Yes,
And how long did you do that?
all my life, church.
Are you still doing that?
Yes,
And you don't have to name your church, but where's your church located?
Fairfax, South Carolina.
So at some point after your children moved up in years or got older, did you start another profession?
Yes,
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
private home care.
I'm sorry?
Private home care, caregiver.
How did you get into that?
My aunt.
And was she in that business?
Yes, she's an LPN. Yes,
An LPN?
Yes.
Licensed practical nurse?
yes.
And when did you get into the home care business?
About 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay. Tell them when you started with the school.
In school in 1995, that's correct, 1995,
And what school did you start with?
at North District Middle School, in Warrenville, South Carolina.
North Central Middle, Varnville.
North District Middle School,
North-
yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change
Yes.
locations?
Yes, 6 years later, I went to Wade Hampton High School,
And for those of us that don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School,
So total years in the school system is what?
28 years,
And you're still there?
still there.
So you started home health care while you were still teaching school, or
No.
still going to school?
Going to school, working, food service.
And will you please tell them, you said your aunt got your business. Were you working with one family at a time, or did you have,
Different families at a time, different families.
and how long would you stay with the family once you became their caregiver?
It all depends on how long, if they're deceased, I will move on to another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said they had a job, and she let me put me on that job.
So to give the jury an idea before we get to this case, your schedule would be what when you were still working at school?
Yes, right
and
at school,
caregiving?
yes.
Okay, so what was your typical day like?
My typical day was I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
Can you tell this jury, Ms. Smith, how it came about that you started working for the Murdaugh?
It was a job opening. I think one of the caregivers mentioned it to me, and I said, yes, I'd be interested in going. And now that's how it started.
And one of the caregivers mentioned your name. Do you know who that was?
Yes, yes, sir.
Okay.
It's Barbara A. Mixon.
Ms. Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up.
Yes.
And can you tell these folks when that was? When did you start working for the Murdaugh family?
It was October of 2019.
And what was your role as a caregiver specifically for the Murdaughs?
Miss Libby, taking care of Miss Libby, Miss Libby.
Was Mr. Randolph, I knew him as Solicitor Randolph Murdaugh, but was Mr. Randolph, was he there living
Yes.
when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeida?
Yes, Almeidas, yes.
What was your primary job as the caregiver? Were you there to take care of Solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby.
Did you also ever tend to Mr. Randolph's?
Yeah, every now and then. Mhm.
But your main focus was Miss
Miss
Libby?
Libby, yes.
From October 19th up to June 21st, Ms. Smith, and I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury there, but did Miss Libby's condition get worse?
Yes,
And she's suffering from something that affects all our families, it's Alzheimer's.
yes,
And that got worse from the time you started until June.
yes. Mhm.
Well, in June of 2021, how would you describe Miss Libby's condition?
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No, no.
All right, specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20, I will leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go back to the school.
So was that the shift you were working for the Murdaughs
Yes,
primarily?
yes,
An 8 p.m. to 8 a.m.
yes.
shift?
Mhm.
When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes,
You would rest?
yeah, that's for a couple hours. Mhm.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes. Mhm.
Well, ma'am, I'd like to take you to June 7th of 2021. If you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh on June 7th of 2021?
Yes,
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital, was he there when you got there on June 7th?
no, he was not.
Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh's, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
And that's the time you were there?
Yes,
And you're never late, are you?
no,
And is somebody waiting to leave for you to get there?
yes.
And this night, who was there?
What's this? Miss Barbara Mixon, I'm thinking.
Okay.
Can't remember. I think it was Barbara.
I'm having trouble
I'm sorry.
understanding your words. Can you speak maybe louder?
Okay.
I know you can't change your voice, but
Yes, sir.
a little louder, please. Or closer to the mic.
Can you tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver, and this was what time of night?
8 o'clock that night.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No,
If they're sleeping, do you want to wake them up?
no.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, hey,
You know, just come in with, change or she need to be changed or whatever like that.
make sure that,
She's
Dry.
She's dry. It's okay, yes.
and so where's your desk, or what's your position when you're there, when you're in her room, Miss Libby's room?
Yes.
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
In a recliner. Have a recliner. Sit there.
And is there a TV in the room?
Yes. Mhm.
And is the TV usually on when you're there with Miss Libby in the evening, or does it,
Yes.
okay. Was it on this night?
It was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Says, a game show.
Say it again?
American Says, the game show.
Okay. How long has that been on?
It's, stays on, it repeats. It's afterwards, repeats itself.
What channel is that on?
The Game Network show. Channel, excuse me.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes.
Okay. Do you remember what time it was? Approximately.
The game show was on, so it had to been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
There's something up in there.
Is it fair to say it was later in the evening?
It was late in the evening, yes.
And you had worked that schedule for that 8 p.m. to 8 a.m. shift for how long?
2 years.
2 years.
2 years.
Was it unusual to see Alex Murdaugh at that residence that time of night?
Yes, on my shift, yes,
And that's the only shift you'd work.
yes,
So the 8 p.m. to the 8 a.m. shift, it was unusual to see Alex Murdaugh there visiting, correct?
correct, yes.
Had you ever been over there before that time of night?
I think different off and on, all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house.
Yes,
What phone did he call? It's a terrible question. I mean, was it your phone, the house phone?
the house phone, the house phone.
And when you answered the house phone, what did he say?
He was outside. They let him in.
He was at the house,
Yes,
right outside the house,
yes,
and he called you,
yes,
and he said, "Let me in."
yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there
Mhm.
at the house.
Yes,
You let him in?
of course, yes.
Do you remember what he was wearing?
Shorts and a t-shirt,
Do you remember what kind of shoes he had on?
those cloth shoes, like Sperry's, that type of material, like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, yes.
And you said something called Spears?
Something like Sperry's, that, that kind of, but it was cloth, that kind, yeah.
Wasn't boots?
No, it wasn't boots, no.
Are you familiar with tennis shoes?
Yes,
Was it tennis shoes?
no, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes,
Did he have any socks on?
no.
Tell the ladies and gentlemen of the jury, could you describe Alex Murdaugh's demeanor on June 7th when you were there with him and his mother Libby?
He just
How was he
came,
acting?
like, fidgety, this came in,
Speak up, please.
fidgety, I'm thinking, it's normal. Like he was fidgety, like, yeah,
Fidgety.
yes,
So saying. And did he tell you why he was there?
no, he just came to see his mother.
Did he talk to his mother?
But she was asleep, yes.
She was asleep. Okay. And what did he do? What did Alex Murdaugh do when his mother was asleep?
He came and sat on the bed, because we was asking me what I was watching, I said American Says, I said a game show.
Did he say anything to his mother?
We said, hey, Mom, how you doing? Just came to check up on you, yeah.
Did he say why he'd come to check up on her?
Because Daddy was in the hospital, called him Hansel, was in the hospital.
And in your opinion, as being there, her caregiver, did she even know that he was there?
No,
The objection's overruled.
You said no?
no.
How long did he stay in the room with y'all? When I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
No, he was laying on the bed.
Did he have his phone with him?
Yes,
Was he looking at his phone?
yes, he was on his phone, yes.
I'm sorry, ma'am. What?
Yes. Mhm.
After that initial conversation, he said, I'm here.
Mhm.
Did he have any other attempt to have any other conversation with Miss Libby?
No,
Can you hold your hand out? Did he ever hold her hand?
yes, he did hold her.
He held her?
Mhm.
Did
She
you
was-
talk to her?
Yeah, she was in the bed, yeah. Yes,
And her condition then was what?
she was, sleep off and on, sleep.
How long did he stay there? I forgot.
20 minutes, about 20 minutes.
20 minutes.
About 20 minutes.
What happened after that?
He left.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Ms. Nixon?
Yes,
Did you learn what had happened at Moselle?
yes.
At some point after that, did you get a call from a family member? I really don't know who it was, but did you,
Yes, yes,
do you remember who it was?
yes.
Okay, who was it?
This is Randy,
Randy Murdaugh.
Randy Murdaugh, yes,
Alex Murdaugh's brother.
yes.
And as a result of that, what was were you expecting people to come over after that?
No,
After that phone call, were you expecting people to come spend the night that night?
yes.
Okay. Who was going to come over?
Randy told me, John Marvin, Buster and his girlfriend, and Alex.
John Marvin, Buster and his girlfriend, and Alex.
Yes,
And did you, and in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you got a call from Mr. Randy saying they were coming? Did they come?
yeah, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No,
Did he ever come looking for glasses?
that morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
And Mr. Randolph, or Solicitor Randolph, died shortly, a couple of days after that.
Yes,
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
yes,
And were you happy to do that?
of course.
And do you remember the day of Mr. Solicitor, I'm gonna call him Solicitor, that's the way I know him, Solicitor Randolph's funeral?
Yes,
And I've been reading through all this stuff. What's a repast?
I repasses, but everybody come back after the funeral to eat.
Everybody comes back and eats?
Yes,
Well, after the funeral, did people come to Alameda, sort of like a visitation after a funeral?
yes,
Did folks come over there then?
yes,
And was the family there then?
yes.
And during this repast visitation, where were you? And I said, what was your job during that, or what were you doing during the visitation?
I was in the room with Miss Libby, just back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes,
Tell the jury about that, please.
he came in the room,
You'd speak up, please, ma'am.
he came in the room and speak that, spoke like he always do.
And what did he tell you?
That he was sitting at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house? When?
The night of the murders.
The night of the murder.
Yes.
What was he telling you about that he was at the house the night of the murder?
That he'd been there 30 to 40 minutes.
Was he telling you that? Did he ask you anything about that when he was talking to you?
Yes.
Did he indicate to you what he wanted you to do with that information?
No, no.
What did he say?
He just said that he was at the house for 30 to 40 minutes. I said,
He said what? Was he there 30 or 40 minutes that night?
Not to my recall,
Why are you crying, Miss Smith?
because they're a good family, and I love working there. And I'm sorry all this happened. They're good people, you know.
He wasn't there no 30 or 40 minutes, was he?
No.
Can't leave the witness.
Did that conversation upset you?
Somewhat.
You upset right now?
Yes,
Did you call anybody about it?
my brother.
You called your brother after that conversation with Alex
Yes,
to tell him about that conversation.
yes.
And just to be clear, what was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know
I was here 30 to 40 minutes.
not to pry, but I can't help it sometimes. What else is going on in your life right there?
Just working hours and hours.
You're whispering. I don't understand what you're saying.
When you gonna get married?
I was planning on getting married. I was planning on to.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes,
And when was that?
day afterwards, I'm thinking.
The day after this?
I'm thinking it was,
After
yes.
the conversation you
Yes.
just said? Where were you?
At the house.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, just let me know, because I know wedding's gonna be expensive. I said, well, thank you.
The wedding's gonna be expensive?
He said, wedding's gonna be expensive. I said, well, thank you.
Did he offer to help?
Yes, he offered. That's the type of person, a good person.
And did he ever mention the wedding to you before?
No, mm-mm.
Did you mention that to him before?
No,
Hey, did he have a conversation, anything else about your job? Were you working at the school?
yes, at the school, yes,
Did Mr. Murdaugh mention to you about your school and your position there?
yes.
Tell him what he said, please.
He said that, if you need a position at school, my good friend is there. I said, yeah, I know, worked at the school, the principal.
I believe you testified, did you help out more than just your regular shift the rest of this week?
Yes,
That week after
yes,
the murders and Solicitor Murdaugh's death? Were you working full-time then, trying to help?
yes,
Was school out then?
no,
So you still going to school and helping?
yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes,
Do you know how long it was, how many days after the funeral of Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning,
Say that again.
6:30 that morning.
And that had been a part of your regular shift, right? 8 to 8 a.m.
Yes,
And did he call you and tell you he was coming?
no,
You didn't? Had he called you on June 7th and told you he was coming?
yes,
And he was right outside the house?
yes,
And this morning at 6:30, he did not call you?
no.
How did you know he was on the premises?
He knocked by the bedroom, near the window,
Not.
yes, on the wall.
Well, did you hear him say anything after that?
He said, I'm outside,
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir.
Never.
No.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex Murdaugh.
He came in the white, left in the white truck, came in the white truck.
Was there still funeral stuff's not in the world. There's still funeral equipment in the yard.
Yes,
Like what?
the tent was still there in the big old building, they put the food in, had out there.
Like a food truck?
Yeah, food truck, yes, there.
Was that blocking your view some?
Yes, block my view, yes.
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
Yes,
Then what did he do?
came inside.
And was Miss Libby sleeping?
Yes, she was still asleep.
Okay. Did he go check on Miss Libby?
No, he didn't come in, no.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
Okay.
Mhm.
And did he have anything or was he holding anything?
He had a blue something in his hand,
Say that one more
a
time.
blue something in his hand, something blue.
A blue something in his hand.
Mhm.
And can you show me how he was holding it?
Like this.
Sorry if I touch it.
Yeah, that's fine.
How was he doing it?
Like this.
Holding something like this?
Yes,
And what did it look like?
like a blue tart, like a tart,
Blue?
blue.
Okay. Was it vinyl?
It's like a tart that you put on a car, you keep your car covered up.
Big thing.
Yeah, blue.
And was he holding it like this?
It's like this.
Could you tell if there was anything in it or do you know?
No, I couldn't tell.
But not holding like this.
Mhm.
Did he say anything when he walked in?
No,
What did he do when he walked in?
went upstairs.
Of course knows. States 230. $223, $222, $413, $412. At this time, without objection, I'll save the other two.
They're admitted without objection.
You testified Mr. Murdaugh came in your Alameda residence that morning. This is States 223. Do you recognize that?
Yes,
What is it?
upstairs, going upstairs.
And is that where he went, Alex Murdaugh, that morning,
Yes.
carrying some blue thing?
Mhm.
And this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house.
Yes,
States 413. What is this?
that's the bedroom,
Where in Alameda is this bedroom? First floor, second floor?
first floor.
Is this where Miss Libby stayed?
No, mm-mm.
And 412? Is that the same?
Yes, same bedroom, yes.
I'll show you what's marked 411. Don't call out the answer. This is States 411 for identification at this point. Do you see the blue object in the center.
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue.
Is it vinyl?
Yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is state's 411 we'd offer at this point. Let me just, I don't know how to ask it except to ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay, where did you see it?
in the bedroom,
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize. Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes,
Did you come? You ended up leaving at some point that day, right?
yes.
When you came back the next day, was that there?
No, it wasn't.
It was gone.
Yes, it's so.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no,
Did you actually see him leave the house after he went upstairs?
yes.
And where did he go?
Oh, I don't know. He stepped outside and left.
Okay. Did he say, "Hey, I'm leaving"?
Yes, he said, I'm going, yes.
And at that point, what did you think? Did you think he'd gone?
I thought he left, yes,
Okay. Did you see him after that?
yes.
Tell them where, please.
He came
That
back,
morning.
he came back to the house.
And how do you know that?
Because the blind was open, I seen him came through the driveway.
And what did you see him? Was he walking? Was he driving when you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, what truck was he driving?
the white truck.
Whose white truck was it?
I'm thinking it was Mr. Reynolds. I thought it was his truck. He had the white truck also.
He had a white truck also.
Mhm.
So when you saw, you testified, Mr. Murdaugh coming back in a white truck, that was Mr. Randolph's truck?
Mhm.
Whose truck was it?
I don't know.
Ma'am, you must use words as opposed to, or because we need to know exactly what you're saying. Say yes or no if you can.
Whose truck did you think it was?
I thought it was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day of that, the same morning.
Same morning when Mr. Murdaugh was there.
Yes,
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone? You know where he went?
no,
And when he came back in this white truck, what did he do?
he got another truck,
How long was he gone?
for about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there in the way, so I couldn't see.
So that blocked your view.
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck. Black.
You know whose that was?
No,
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
they had a little cut, a little cut or something,
And ma'am, I apologize, a little what cut?
like a little bruise or something.
Where was it?
It's like above his forehead,
I won't ask you to touch me, but can you touch yourself to show where?
right here, something like that.
Did it look fresh?
This looked like a cut, not, I wouldn't say fresh, but it looked.
video system in the house for either Sister Murdaugh or Miss Libby Murdaugh?
Yes,
Can you tell them about that? Where was that? What was that?
it was in the Miss Libby's bedroom.
And how was that activated or operated? It's better. Do you know?
No,
Was it on all the time or not?
yes,
And what color would it be if it was on? Was there a marker that, or red and black or red and green?
no surplus, yes,
And would there be times when that wasn't on?
yes,
And do you know who controlled it?
no.
I'm going to show you what's marked 410. Do you recognize this?
Yes,
Okay. And does it relate to what we're talking about this morning as far as your location?
yes,
Your Honor, 410, I believe without objection.
Says it relates.
Her testimony, where she was at.
No objection.
It's admitted. Without objection, it's submitted.
Can you see this on your little, you got a little thing up there? Do you mind coming down here? Judge, can she come down here? Yes. Very briefly, it won't be long. If you would stand up there, so just we don't block the jurors, please, so Mr. Griffin can see. Is this a picture of what we refer to as Alameda?
yes,
And can you show where the, I guess I called the main house? And I'm sorry, we don't have a pointer. That's the main house. And you have to say yes for the record, please, ma'am.
yes,
And down here, I know it's hard to see. Can you tell what that is? Sorry. Can you point to the main house again? I thought you blocked the yours. That's all good.
right here.
Is that where you took care of Miss Libby?
Yes,
Now, down here, there's even a little O on it. Do you know what this is down here? Let me ask you this, what other buildings are on the property?
the smokehouse and a barn, another little shed
And where were the ATVs usually?
at the smokehouse.
Where's the smokehouse?
That's it, right here.
There you go, that's the smokehouse.
Mhm.
And that's where the ATV
Shed.
was.
Yes.
And where did the ATV end up when you saw it after you thought Mr. Murdaugh left? Had it moved?
At the main house,
Say that again, please,
at the
ma'am.
main house.
Okay. And when you saw him coming back, you thought he left. Where did you see him in the white truck? Do you remember?
He left him across the railroad track, you know. He left him across the railroad track and went out.
Which way to railroad tracks?
This way, I mean, that's the house. So had it been around, because had to drive through.
Speaking up.
I'm trying to-
That's good. Go back and sit down. That's
Until I
fine.
could
Thank you.
see.
Now, have you talked with either Mr. Griffin or Mr. Harpoon or one of their investigators?
Yes.
Okay, when was that? Best you remember. I'm not looking for a date and time, but you know how long ago?
It was last year.
And I met with you a couple of weeks ago,
Yes,
and just a little while ago this morning.
yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes,
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in? Is that him?
yes.
Thank you, that's all.
Good afternoon, Ms. Smith.
Good afternoon.
We have met once or twice. Did anyone ever show you a blue rain jacket?
No, no, that. Yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket.
Yeah,
correct?
picture of it, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No,
Now, you saw Mr. Murdaugh bring a tarp in, you said, right?
yes,
And I'm going to show you a tarp, which we marked for identification purposes, Your Honor, Exhibit 86. Is this the type of tarp that Mr. Murdaugh came in to the Alameda house on the day that we're talking about?
yes,
Tarp like this that would maybe cover up a car. Is that right?
yes,
Any way to confuse this with a rain jacket?
no,
He was not carrying a rain jacket, was he?
no, it was balled up. I don't know it.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up. Is that right?
Correct.
Have I balled it up sort of correctly?
Yes,
All right.
No, we have no objection to going in.
Your Honor, move Exhibit 86, I think, in evidence.
Without objection.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
yes,
And you had, and when you left for end of your shift that day, that's where it was, right?
yes,
And you've never seen it since, correct?
correct.
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
No. In the closet.
Do we have that picture? That's the last photograph that went down. Can you see that, Ms. Smith?
Yes,
Do you know where that is, or even if it is in Ms. Libby's house?
I can say because I don't be in the closets. I don't know.
So you don't even recognize the closet, is that right?
Correct.
And have you ever even been upstairs in Ms. Libby's house?
Twice,
2 times over how many years?
3 years.
2 times in 3 years. And do you know where Alec Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
No,
Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral. Is that right?
yes,
Okay. And it was early in the morning?
yes,
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
yes,
So then it would be Monday, Tuesday, Wednesday of that week. Is that right?
yes, that's correct.
And is that the morning that you said that you thought you saw a bruise on his forehead?
Yes,
So it was Wednesday after Mr. Randolph's funeral.
I'm thinking I can't remember. It was so long, I can't remember.
Yes, ma'am. And and you mentioned that that he came in a truck. I think you said he drove up in a white truck.
Mm-hmm.
Is that correct?
Yes.
And he does have a white truck, as
Yes.
far as you know, right?
Yes, yes,
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alec's truck that he left in?
because it was moved. Mr. Randolph had always keep his truck in a certain position, certain part.
So you think he left in Mr. Randolph's truck and moved?
Yes,
And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway,
yes,
parked in its normal place?
yes,
Anything out of sort?
no,
Was it all covered up with mud, like someone's been mudding in it?
no,
Anything unusual about the truck?
no,
Now, you mentioned there was a 4-wheeler that had been moved at some point in time. That 4-wheeler had a flat tire, didn't it?
yes, it did.
Okay, was it a front tire, back tire?
I think it was a back tire.
And it was moved up close to the house,
Yes,
far as you know, so the tire could be repaired
yes, it was moved from the smokehouse to the record house. Yes,
with a flat tire.
yes, with a flat tire.
Now, you were asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes,
And he said he was there 30 to 40 minutes.
yes,
And you said, no, I don't think it was that long.
yes,
And then the next day, I think you said, or day after, well, the following day, or I guess other than Monday, you had another conversation with him where you just brought up fact that you were going to get married. I think you said that was a different day, right?
yes,
And he was just being nice, wasn't he?
yes.
I think you used the word good
A
person.
good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Now, he came over on the night of June the 7th. And you said it was somewhere between 8:30 and 9:30 in the evening.
Yes,
And that's just your best estimate of when he got there, is that right?
yes,
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
yes,
And when you said 15 to 20 minutes, you're talking about 15 to 20 minutes in the room with Ms. Libby or on the property the whole time?
been property the whole time, thank you.
Okay, well, now you said it took you about 5 minutes to let him in, is that right?
Yes,
So are you including the 5 minutes it took you to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes, the only thing is
No.
the whole time, so.
And you would agree that Alec Murdaugh would visit his parents frequently, right?
Yes,
And he would always come over more so than any other sibling, is that right?
yes,
And you would agree that it was not out of the ordinary for Alec to come at night, correct?
yes,
You would agree with that, right?
no,
So you don't agree that is, so was it out of the ordinary for him to come at night?
yes, on my shift, yes,
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? You remember that?
yes,
And you remember telling him that it was not out of the ordinary for Alec to come at night?
yes, it's been a long, I couldn't remember. So it's been a year now, so I can't really remember.
I mean, is it possible that you told him that?
Yes,
And here today, you said, as I have in my notes, that when he came over, that he was acting kind of fidgety, yet normal. I believe that's what you said.
mhm,
Is his normal behavior kind of fidgety?
yes,
He's just kind of a fidgety person, right?
yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
But he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes,
Okay. Now, you mentioned the clothes that he was wearing. And he came in and he sat on his mom's bed,
yes.
lay down next to her,
Late,
and held her hand. Is
He
that
walked
right?
in and hold her hand and spoke to her, then went on the bed and lay down.
And lay down.
Not lay down, but sit up.
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall that I didn't touch it.
Okay. What did Alec Murdaugh have blood on his clothes?
No. I
He
didn't-
had blood on his shoes.
No,
He had blood on his hair.
no,
Did he leave blood in his mom's bedroom?
no,
Now, according to the records that we've been providing in this case, you were interviewed by SLED on June 16th. Do you remember that
yes,
interview?
yes,
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes,
And then you were interviewed again by telephone on June 17th. Do you remember that follow-up call? You remember having a short phone call on the 17th?
a phone call.
Okay.
Mm-mm.
Well, whether it's one interview or two interviews, you never told anybody at SLED in June, in these interviews, one or two, anything about Alec coming in with a blue tarp, is that right?
Right.
You didn't say anything about a blue tarp until sometime in September, is that right?
Yes.
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale Police Department when he was working a wreck. Do you remember that?
Mm-hmm.
Is that yes?
Yes.
Okay. And you had been in the automobile accident, and Officer Dingle was working the wreck and I guess filling out an incident report, and you were having a conversation.
Yes.
And in that conversation with Officer Dingle, didn't you tell Officer Dingle that on the night of the murders that Alec came over with a blue tarp that looked like it had a gun in it?
No, I sounded like he was holding something.
So you didn't say,
I didn't say specific was a gun. I said he was holding something.
so you didn't tell Officer Dingle that he came over and you couldn't tell, but stated it looked like.
I said it was something. I did not say it was a rifle.
And if Officer Dingle wrote a report up saying that, he was just incorrect.
Yes.
And then after you had this conversation with Officer Dingle, then you were contacted by SLED agents, right?
Mm-hmm.
And they asked you to go down to their offices, and that's where you were interviewed in September, right?
Yes.
And in that interview, you told them about a blue tarp that you put over your car, just like this, right?
Mm-hmm.
Is that correct?
Yes.
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle.
Right.
And since that day of the interview at the Low Country SLED office, have you had any additional interviews with SLED agents other than getting ready for trial last week?
Yes.
How many additional interviews?
Two or three.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alec Murdaugh walking into the house with?
Yes.
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
It was balled up as a blue tarp.
So you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes. Yes.
One second, Your Honor. Just one more point. When Alec Murdaugh came over on that early morning, I guess it was Wednesday, you testified. Were you in Ms. Libby's room?
Yes.
And you can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you?
Mm-hmm.
You can?
No.
Okay. Thank you, Your Honor. That's all the questions I have.
Redirect.
Testifying in front of the grand jury on January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total, do you remember that?
Yes,
Do you remember your answer being 20, 10, 15, 20 minutes?
yes.
Mr. Griffin asked you about the 30 to 40 minutes. Why'd you call your brother after that?
Because he's a chief, assistant chief police at Warrenville. So I called him.
Had that statement by Alex Murdaugh affected you?
Yes,
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No,
And his 9:30 visit the night of the murders, that was very unusual for him to be at night, wasn't it?
Objection, leaving.
Don't leave the witness.
I'm sorry.
yes,
Was that unusual?
yes.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying
Yes,
before you told anybody else?
yes.
And what was that about, a traffic accident?
I had someone hit my car. He was on duty,
And when was that?
September 11th.
That's my birthday. You had an accident, and you told the officer that you had seen him, Alex Murdaugh, come in holding something,
We was talking, was having a conversation, and that came up.
and you just told him that.
We was talking.
Had anybody asked you that before?
Mhm.
You have to say yes or no.
Yes,
Anybody had that before?
no.
Okay, so why did you tell the officer that on September 11th?
We was having a conversation and just talking in general. And he asked me a question, and I said, yes, I've been there. I said, I work with the Murdaughs. His mother,
In response to him, you told him you saw Alex Murdaugh with what?
a lining, a blue tart,
And you saying tart or tart?
like you cover a car with a tart,
And you said you saw him with that, and did it appear he was carrying something?
like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes,
Like this?
yes.
So you never saw this unfolded?
No, and that was
Never.
till the next morning, that was on the chair in the living room.
And you don't know where this tart came from, do you?
No, I don't know where it come from.
And it didn't have silver on one side, did it?
No,
It was all blue.
all blue.
And you said that the defense took a statement from you?
Yes,
Did they record it?
yes.
John, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking the stand.
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, I think once the witness is taking the stand and she said that they took a statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
It says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
Your Honor, we do have a copy here. I don't know if we can download it to, yeah?
Judge, I mean, I can't look at the flash drive, but yeah, I guess. Is it a hard copy?
Not a written statement, it's an audio recording.
Opportunity to listen to that without the presence here. I'm assuming it'll be a hard copy, but I don't want to mess the court schedule up either.
Now, ladies and gentlemen, we'll have you go to the jury room. Please not discuss the case.
So I'm not quite sure what's going on here. Mr. Dingles, I agree 100%, Sunshine, 100%.
Good, tell me you got a written transcript.
We'll be at ease momentarily.
What was that I missed? So I wonder if they'll give them lunch or just carry on because they didn't start until late. Okay. Trying to get set up for the next stream. And before we go, I'll stop quickly and see if there's anything going on with that earthquake. February. Hey. What do you guys think? What the hell, eh? So let's see here, Mexi. They also witnessed about something that wasn't entered into evidence, and now the state wants to ask the questions about it, but it's not in evidence. So they're going to have a little powwow about it. I think the judge is going to be over these people's BS if he isn't already. Fair enough. Like, what the hell? Afghan. Where was that again, guys? I know that they've had 2 now, and Turkey. I had to look up at my tabs. It was in Turkey, and they had 2, one right after another. Many, many lives lost, sadly. Oh, here comes the jury again, I think.
Please be seated.
No.
Well, let's see, if you need a half an hour to listen to this tape, we can take.
We have a rough draft of a transcript that we're emailing to them but it's 57 pages long, but we're sending it to them.
What a bunch of shady effing people. Yeah, Turkey.
A rough draft.
I'd like to look at the video at this point.
All right, we're going to bring the jury in and break for lunch.
Yeah, that's fair enough. They can do this during lunch, right? It was what, 7.8 and then 7.9? That earthquake? We'll take a look at it after we're done up here and see what's going on really fast. And then we'll break for lunch and I will set up the stream for the afternoon. And we can either look at the Eagles or Turkey or try and get in both. Their mornings are always longer, like we're going on 4 hours again. And we're usually done up. So it's what, 1:13 their time. Oh, did they, Mexi? What the F? Yeah, little minor ones. So are they having like the reverberations, or are they having like, hey girls, yeah, you got water in your bowl. You don't have to drink my plant water. No, you don't gotta. Unreal. The way he stares down witnesses should not even be close to
All
acceptable.
right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30, till 2:30. And this is, juror number 729, I'll speak with you during lunch. So you can return to the jury room, please.
So are they going for lunch?
We're going to take a break for lunch. You just cannot discuss your testimony with anyone during lunch, but you can step down and have a good lunch. And we will be in 2:30.
Okay, so I'll set that up for 2:30 Eastern, 12:30 Mountain Time. So I did say we would take a quick look at what's going on in Turkey. Let me see here. I think I had... I don't know if this is... I think this is a different News Nation, but let me refresh it. Okay, yeah, I don't like that one. Let's see here. I can try those ones. Let's see. Oh, that's the buff one. I want to find one I know is not going to give me trouble. But it's CNN and this News Nation is not our News Nation. I don't think anyways. No, because it's got 7.4 million. I'll go over here again. Okay, I'm going to try that for a minute. Looks like it could be a good one. Okay, looks like we might just get let me find it here. Sorry, guys. So we won't go on here long, but it is giving updates, and this is from ABC News.
The epicenter of the quake in the Turkish city Kahramanmaraş near the border with Syria. the most powerful earthquake to strike Turkey since 1939. But 9 hours later, as rescue workers search for survivors, a second earthquake.
Is that getting through, you guys?
This one, 7.5 magnitude.
This again. Okay, so I'm going to start it over.
(1939). This morning, enormous devastation in Turkey and Syria. A massive 7.8 magnitude earthquake striking overnight. Terrifying video shows the moment a building starts to collapse. In Syria as well, streets flattened. People desperately digging out survivors in a country already devastated by war. Many of those affected, refugees. The death toll in the thousands. Hundreds of buildings collapsed. The epicenter of the quake in the Turkish city of Kahramanmaraş, near the border with Syria. The most powerful earthquake to strike Turkey since 1939. But 9 hours later, as rescue workers...
Oh my God. Unreal. All of these buildings are going to be extremely unstable. Like, everyone needs to get the hell out of there.
Searched for survivors, a second earthquake. This one, 7.5 magnitude,
Wow.
80 miles from the first. TV cameras capturing it as it brings down a building. Turkey's President Erdogan saying this is the worst disaster his country has faced since the 1939 earthquake, which killed 30,000.
Wow.
Rescue workers hampered by bad weather, those left homeless facing cold and in some places snow. The US State Department overnight issuing a statement saying President Biden has directed US aid and other federal government partners to assess US response options. Dozens of other countries offering aid as frantic efforts to save lives continue.
Oh my God, eh? Oh, hey.
Turkey and Syria.
The death toll is rising after the magnitude.
Unreal. Yep, death toll nears 2,500, more than 4,200 buildings destroyed. And Monday's quake was as powerful as the strongest ever recorded in Turkey. Wow. Look at that. Oh my goodness. Wow. And then there's the one Mexi sent to me, and this was in a smaller one. This is in the US, in New York. So this is Buffalo, New York, hit with the strongest earthquake in 40 years. A magnitude 3.8 was felt in Buffalo, New York, February 6th. Well, sadly, things are getting out of control as far as the weather. This is the nicest, if you want to say that, the nicest weather that we've had in memory. So we were talking about the ruins and hoping that they were not destroyed. And sadly, CNN has put something out that says that the earthquake was struck struck Turkey and Syria on Monday, has leveled the, I'm not sure how to pronounce this, Gaziantep Castle, and it's a historic site that was a tourist attraction in southeastern Turkey. Death toll nears 2,500. So that is where we're at with that. Was it 30,000 in 1939? Yes, heartbreaking all the way around. And yeah, I'm wondering about the aftershocks. That's exactly what I was wondering about, Dar, is they're going to continue. Oh, Dandy. My heart can't handle all the devastation. How sad. It really is. We wish we could get to the point of a wake-up call when it comes to preserving our planet. I think we're past preserving our planet. Ugh. So guys, I am going to jump off. I've got to set up that next live. So that's going to be, let's see, what did they say? 2:30 their time. So that's about an hour from right now, but I'll set up right away. And we could decide if we want to look at this or if we would like to look at, the eagles and the pandas and what have you. We can talk about it when we, mix it. Yeah. So I'm going to jump off and I will absolutely see you guys in the next one. Thanks again, as always, for staying and hanging out with me. I appreciate every single one of you and love you, Dar. I will see you guys in the next one. Bye.